Hello everyone. Now let's see definitions. Definitions are very simple in this. The main definition to be seen is India, because import and export means importation into India, exportation out of India. So coming in and going out of India is important, and that is the taxable event, import into or export from India. So what is the definition of India, and when can we say that the goods are imported, and when can you say that the goods are exported? So that is the main thing to be studied in this chapter. Let's see. So the definitions are given line wise. First, export, taking out of India to a place outside India. Taking out by itself is not export. There should be a place outside India where the goods are taken. Means there should be destination of the goods out of India. If there is no destination, then that cannot be called as export. Okay, so taking out of India to a place outside India. And what is import? Exactly the reverse of it, bringing into India from a place outside India. So this place refers to place of origin, from where the goods are coming. So there should be origin outside India, from where the goods are coming into India, bringing into India from a place outside India. Next is India. What is India? It includes the territorial waters of India. So section 227 says India includes territorial waters of India. Then what is territorial waters of India? So that all you know, up to 12 nautical miles from the baseline. The sea which extends up to 12 nautical miles is called as territorial waters. And if you want more statistical details, then 1 nautical mile is equal to 1.853 kilometers. So the kilometers that you see in your vehicles on road, that 1 kilometer is not equal to 1 nautical mile. The nautical mile means the mile which is measured on the sea is equal to 1.853 kilometers. Then there is Indian custom waters also, which extends beyond 12 nautical miles up to 24 nautical miles, is called as the custom waters. Now the importance of custom waters is that we'll see a lot of provisions later on at the end of this customs module regarding the powers of the government to check the goods and all. So there are 2-3 chapters at the end, interesting chapters. So in that we'll see that the customs department has the powers over the customs waters. Means if any vehicle comes in to 24 nautical miles, the customs department has the power to go check the vehicle, check whether the goods are imported, exported, check the smuggled goods, and so on and so forth. So they have a lot of powers over that. Then it includes any bay, gulf, harbour, creek, or tidal river. All these are different forms of water bodies. Bays are this, like we call it Bombay. So Bombay, because bay is an interior part of the water. There are land extending up to here, and the sea is coming in and forming a big area, so that is called as bay. Gulf is even a bigger area, then it is called as gulf. Harbour everyone knows, and we can have harbours in the sea also. Extended harbours they are called as. Then creeks and tidal rivers. Creeks are sea water coming inside. It's like a river which is coming into the landmass, but it is not a river. The water is flowing from the sea into this creek. So in high tide it fills up, in low tide it then settles down. And similarly tidal rivers. Tidal rivers are in Gujarat and all, so Kutch area. So they are rivers which fill up by sea water. So when the high tide is there, they will get fill up, and when the low tide, it percolates down. So all these are included. All these types of water bodies are also included in the definition of custom waters. Then the central government has got powers to take measures in this area for security of India and immigration also. People who are coming in and going out. Then significance and importance of custom waters. Why it is important? The customs officer has power to arrest a person in India or within Indian custom waters, to stop and search any vessel in India or within the custom waters, and if such vessel does not stop, it can be confiscated and even fired upon. So all these powers are there. This we'll see in detail later on. Then there is exclusive economic zone and continental shelf, which extends up to 200 nautical miles. This we had studied in GST also, same definition is there, which extends up to 200 nautical miles from the baseline, means from the seashore. And in this zone, the coastal state has exclusive rights to exploit it for economic purposes like constructing artificial islands for oil exploration, power generation, etc. Then fishing, mineral resources, and scientific research. Beyond 200 nautical miles is called as the high seas. So in high seas, no country has rights, where all countries have equal rights. So no country can claim ownership of high seas. Up to 200 nautical miles, India has the power to exploit the natural resources. And these high seas are reserved for peaceful purposes. Of course, nothing is peaceful these days. Then custom law extended to maritime zones. Maritime zones means this continental shelf and exclusive economic zone. So it says the central government has extended the Customs Act 1962 and the Customs Tariff Act to notify designated areas in the continental shelf and exclusive economic zone, that is up to 200 nautical miles, and whole of the continental shelf and exclusive economic zone for the purposes of. Now see, you read A and B, and then I'll explain what is the difference between A and B. Prospecting for or extracting, add a word or in between, prospecting for or extracting or production of mineral oil, including natural gas, in the continental shelf of India or the exclusive economic zone, and supply of any goods defined in Customs Act in connection with the activities referred to in 1. Means in connection with the extraction process. Now see, I'll explain you this point. What it means, first is designated areas. Designated areas in the continental shelf and exclusive economic zone. Continental shelf and exclusive economic zone extends up to 200 nautical miles. So it goes even beyond the territorial waters of India. So in that big area, which is the continental shelf and exclusive economic zone, government will define certain areas which will be called as designated areas. Like an extended seaport can be built there, or an artificial island can be constructed there, or a natural island may be there. So those islands and port area and any economic activity area will be called as designated areas. So these designated areas will be considered as part of India. Okay, means the Customs Act is extended there. Extended means that they will be considered as part of India. So if any goods come there in the designated area, it will be called as import. Or if any goods go out of there, it will be called as export. Okay. So designated areas means the defined areas. Like for example, if this is the landmass, okay, then this is the 12 nautical miles. Then there is customs 24 nautical miles, and then there is the 200 nautical miles. So this 200 nautical miles, this is called as the exclusive economic zone. So in this area, rather beyond 12, normally India includes territorial waters of India. So these are the TW, territorial waters of India. So if any goods come into this, it will be considered as import. If any goods go out of this, it will be considered as export. But what about this area? This is the customs area in which various customs procedures can be adopted. But what about import? From 12 till 200, this area will be considered as part of India for two things. One is the designated areas. So government can designate certain areas and say that these are part of India. So anything which is coming out, coming from outside to these areas, these are designated areas. Any goods, any type of goods which comes in to these designated areas will be considered as import. and any goods taken out will be considered as export. Any goods, it can be anything. Apart from these designated areas, the whole of the exclusive economic zone, whole of it, is considered as part of India for one purpose, and that is oil exploration, extraction or production. So if you're exploring some oil, that is, you are basically building an oil rig for exploitation of oil and natural gas. So for this purpose, the whole of the sea water up to 200 nautical miles is considered as India. So anywhere Reliance goes, or ONGC, or Bharat Petroleum, or Indian Oil Corporation, they go and set up a production plant there, it will be considered as part of India. So what this means? This means that anything that you import for this purpose, any goods which are imported for the purpose of this oil well, any goods coming from outside India will be considered as import, because this is part of India. Secondly, oil which is produced from this oil rig brought into the landmass will not be considered as import, because it is India, because this is India. If this is India and coming into India, will it be called as import? No, not an import. And thirdly, any oil produced here taken out, the oil produced here is taken out, will be considered as export, because this is part of India. If this is part of India, I am taking out of India, exporting it, so that will be called as export. Understood? So for oil industry, up to 200 nautical miles is considered as India. Otherwise, India normally includes 12 nautical miles. So territorial waters is always part of India for any goods. Territorial waters is part of India for all goods, any goods. Beyond 12 nautical miles up to 200 nautical miles, two things: designated areas, then any goods, for any goods it will be considered as import export, and the whole of the designated area for oil exploration, extraction or production. Understood? So any goods coming in is import, any goods going out is export, and goods coming from there to India is not an import. Similar for these designated areas. Okay, great. So then see, therefore the aforesaid areas form part of India for the levy of customs duties. And then the implication is given there. Any goods produced or manufactured within such area and brought to the mainland will not be regarded as imported goods. So no import duty, no custom duty will be charged. So the oil which is produced in the continental shelf and exclusive economic zone and brought to India, like ONGC's Bombay High is there, and other in Kaveri Basin also and Godavari Basin. So that oil which is imported into India, coming into India, will not be considered as import. Secondly, any goods brought from any foreign country into such area will be considered as import. It will be treated as import and import duty will be charged. And supplied from the mainland to such areas will not be export. From the mainland, from the landmass, if you supply something to these areas, it will not be export, because that is part of India. And fourth one is not given, right? The fourth one also. Any goods supplied from such area to outside India, like oil export. If you supply oil from there to outside India, then it shall be considered as exports. Okay, shall be considered as export. Then that diagram is given here also again, that this is the landmass. So up to 12 nautical miles is territorial waters. From there up to 24 is the custom waters, and next 176, that is extending up to 200 from the baseline, that is exclusive economic zone. And then the high seas. And then again significance of Indian custom waters is given. The gist of these sections is given here, though these sections we'll see in detail later on at the end of our lectures. And then you will understand, you can just read them right here, that if the officer of custom has reason to believe that any person in India or within Indian custom waters has committed an offence punishable under section so and so, 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 he may arrest such person, informing him of the grounds of such arrest. Section 104. Then 106 is there, where proper officer has reason to believe that any vessel in India or in Indian custom waters has been or is being or is about to be used in smuggling of goods or in the carriage of smuggled goods, he shall stop such vehicle, animal, vessel, means ship. In case of aircraft, compel it to land. In case of aircraft, compel it to land. Then any vessel which is or has been within the Indian custom waters is constructed, adapted, altered or fitted in any manner for the purpose of concealing goods shall be liable to confiscation. If you are concealing goods in that vessel vehicle, it will be confiscated. And customs officer has power to search any person who has landed from or about to board or is on board any vessel within Indian custom waters, and who has secreted about his person any goods liable to confiscation or any documents relating thereto. Means the people who are found there can be searched, body search. And any goods which are brought within the Indian custom waters for the purpose of importation from a place outside India, contrary to any prohibition we'll see which goods are prohibited. So if there is a prohibition but still you bring those goods within the custom waters, then what will happen? Shall be liable to confiscation. They will be confiscated by the government. Then taxable event is discussed. So taxable event means importation or exportation, bringing into India, importation, taking outside India, exportation. So what is the taxable event and when does this taxable event happen? What is the occurrence of this taxable event? Now the question arose, and a lot of Supreme Court judgments are given there. Question arose because importation is a long process. It is not like one single moment where the thing happens. No, it is a long process. How? Let me explain. See, this is the landmass. On the landmass there is customs port, or there is airport or land customs station. There are three kinds of places. This we'll discuss in the next chapter. These are three kinds of places where the goods come in, the imported goods come in, and then it is cleared on payment of duty. So these are called as port, airport, and land customs station for land boundaries, land borders. And then there are extended ports also like ICDs and CFS and airport freight station and lot many other. Forget that. Just remember the three for the time being. Okay, port, airport, land customs station. Now this was our territorial waters. Normally India includes territorial waters, 12 nautical miles. Now a ship comes from Australia and it is coming slowly and steadily. The ship in charge is singing a song, and his driving ships are normally, they travel slowly. It's a big ship, cargo ship. It enters the territorial waters. Okay, it enters. This entry is on, say, 10th of November. 10 November, the ship enters the territorial waters. And then it slowly comes in and it goes to the harbour. It docks at the harbour. It's standing there. Then there are a lot of documentation to be done. Okay, we'll see these steps later on. And then after the documentations are complete, the goods will be unloaded onto the port. The goods will be unloaded. I'll explain this concept later on in detail, so don't worry. But just remember, a lot of documentation is to be done first, and then the goods are unloaded into the customs area. Now this is customs port. Within customs port is a big area. Within that there is a customs area. So goods are unloaded into that customs area. They are still non-duty paid goods. Then the importer, whoever is the importer, Mr. Jogi, for example, is the importer. He then comes and files bill of entry. He files the bill of entry. This is the document for clearance of goods. He files the bill of entry. Then assessment is done on the bill of entry by the officer. Actually it is self-assessment. We have to assess the duty ourselves, but then the officer checks whether it is correct or not. Then he returns it to us, then we pay the duty. Once we pay the duty, the goods will be allowed to be cleared. So that is again a procedure. So one procedure is the goods coming in and the unloading, and second procedure is the importer coming in and filing a bill of entry for clearance of goods. Now let's take an example that the goods have crossed the customs territorial waters on 10th November. Then they are unloaded on, say, 16th of November. The goods are unloaded onto the port, and the bill of entry is filed by the importer on 17th of November. Next day he files the bill. So now the question arises, when does the taxable event happen? That's the question. When does the taxable event happen? 10th November. Imposition of tax is on happening of the taxable event, right? Like we had studied in GST. So taxable event is on happening of the event. So does that event happen here, 10th November, or 16th November when the goods become part, when they are unloaded, or 17th November when the bill of entry is filed? What is the date of taxable event? What is the date of importation? Does the importation happen on 10 November? So if you see the definitions, definition of import is bringing into India. Bringing into India, and India includes territorial waters of India. So when can you say that the goods have entered the territorial waters? 10th November means they have entered India. They have entered India on 10 November. So entry into India is importation. So Bombay High Court held in an APAR case. APAR case was there. Many years have gone now. So it was held by Bombay High Court that importation takes place on 10th November. So if the goods are not chargeable on 10th November, now there is a concept of chargeability. The charge has to be there at the time when the event happens. If a charge is not there, means imposition is not there on the date of event, but the imposition is afterwards, then it cannot apply to these goods. It cannot apply to these goods. So on 10 November, suppose there is no charge, and the duty is imposed on, say, 13th November in between, and we go for clearance on 17th November. So officer says that this is 17th November, the goods are chargeable, pay the duty. But we would say, look, importation took place on 10th November, there was no charge. And if there was no charge here, then you cannot put a charge on 17th November on these goods which were imported before the date of imposition of duty. Anything which is imported before imposition cannot be charged, even if clearance is afterwards. So this was the case before Bombay High Court, and Bombay High Court held that yes, importation is on 10th of November. So if there is no charge on 10th November, then duty is not payable on 17th November. But many other courts, high courts, differed in their opinion. So there were lot many judgments. In fact, all the other high courts, Delhi High Court and other high courts, they opined, even Rajasthan High Court decision was there. Their opinion was, Karnataka High Court decision was there, that how can you measure the time when the goods cross the territorial waters? Who knows when? Because water is water. Is there any boundary in the water? Like that toll gate is there? Huh? That you pay something and then you are allowed to enter? No. Who will measure on the sea? So can we say with any certainty, do we have any proof that the ship has entered territorial waters on this particular date? No, first of all. Secondly, there can be so many ships which are not even coming to India. Like a ship is going from Pakistan to Sri Lanka. But it will go in the close proximity because Indian borders are aligned. So when it leaves Lahore or Karachi, it is already within 12 nautical miles of India. Because of the close distances. And if you compare Sri Lanka with India, so within 12 nautical miles is the landmass of Sri Lanka. So if any ship is going from Sri Lanka somewhere else, it is crossing the 12 nautical miles. But it is not intended for India. Will you catch that ship and say pay the import duty because you have come into India? So there can be transit of goods, there can be transshipment, there can be so many ships which are crossing the Indian waters, but they are not meant to enter the landmass. The goods are not meant for India. So will you hold them liable to pay duty? So considering so many different practical scenarios, other high courts had held that no, goods will be considered as imported only when they cross the custom frontiers. Crossing custom frontiers is what? Not 16 November, not when the goods land, but when the goods are cleared or intended to be cleared. So that means that this bill of entry date will be considered as the happening of the event, that is importation. Importation is deemed to take place on 17th November and not before that. So this was held by various high courts, and then later on Supreme Court upholded the decision of other high courts and set aside the decision of the Bombay High Court. So ultimately now it is proved beyond doubt that importation takes place when the bill of entry is filed. Clear? After all the permutations and combinations of thoughts, this is the final decision which is upheld by the Supreme Court. So let's see, those few decisions are given there. Let's go through it fast. Now when this was in old course and it was for around 40 marks, questions used to come on this. Now being 25 marks only and so much to ask from, so you cannot expect many questions on this point, okay, but still we have to study, so let's study once. So first case is given, Garden Silk Mills. Then in case of goods cleared for home consumption, this is called as home consumption. When we file bill of entry and remove the goods, that is called as home consumption. Then there is another way of clearance, and that is called as warehousing. There's another way. So what we can do here is that this is bill of entry. We file bill of entry, we pay the duty, and then we clear the goods. So this is called as bill of entry for home consumption. Home consumption means removal into landmass of India. That is home consumption. Home means India. Okay, not our home. Home means India. There's another way, and that is warehousing. Suppose we don't want to clear the goods right now. We need time. We need time. So you are given time. You can put the goods in a warehouse. So in that what happens is that we file a bill of entry for warehousing first. The bill of entry is filed, duty is there, duty is assessed, but we don't pay the duty, we file a bond. We file an undertaking that we'll pay this duty later on. So we file a bond, then the goods are allowed to be deposited in the warehouse. The goods are stored in the warehouse for the time being, but they are not duty paid. And then later on we can remove the goods on payment of duty from the warehouse. So you file another bill of entry So there will be two bills of entries. First bill of entry is filed at the port for warehousing. So that is also called as in bond bill of entry. In bond means goods are going under bond. In bond bill of entry. Then the goods go to the warehouse. Then at the time of clearance from the warehouse, you will have to file a bill of entry for home consumption. That will be called as outbound bill of entry. The goods are now moving out of bond. So then you pay the duty, the bond will be cancelled. Bond was undertaking. So there is no need for promise because you have fulfilled, you have paid the duty, and the goods will be allowed to be cleared. So in that case, the event will happen when the second bill of entry is filed. Not the first one, but the second one. So in case of warehousing, let me explain that there will be two bills. The first will be bill of entry in bond that you will file at the port. Suppose that is filed on 17th of November. Then the goods go to warehouse, WH warehouse, and then we file another bill of entry for removal for home consumption. That is X bond bill of entry or out bond we get. It is called as out bond or X bond. X bond means moving out of the bond bill of entry. This bill of entry is filed on say 13th of next year's February. 13 February next year. So then that 13 Feb will be considered as the taxable event. So duty which is applicable on 13 Feb will be applied to this case. So in case of home consumption, this bill 17 November. In case of warehousing, not the first bill but the second bill. Understood? So let's see. So first point is for home consumption. It says import of goods commences when they cross the territorial waters of India. So what the code says that when the goods cross the territorial waters, that is when they enter the territorial waters, the import process is commencing. The process commences. It doesn't end. It commences. Import commences. And ends when reach custom barrier and bill of entry for home consumption is filed. That is when it ends. And we have to always see the ending of the process. Levy takes place on the end, not on the beginning of the process. Similarly, another case, Aban Lloyd Chills, whatever you call as offshore limited. That oil rigs located beyond the territorial waters of the country but within exclusive economic zone in notified designated areas are within India. We saw this point. So vessels carrying stores to such oil rigs cannot be considered as foreign going vessel. If we are sending some stores means things which are used on these rigs from India. So a vessel which takes the goods from India to these places is not export. It is within India. Okay, so it will not be considered, cannot be considered as foreign going vessel. The vessel will not be considered as foreign going vessel. It is Indian vessel. Therefore, these imports are not eligible for exemption or be considered as export, as oil rigs in EEZ or continental shelf are not foreign going vessels. Simple. Now you will not understand these points. Actually what happens is that when we import the ship stores into India, when we import ship stores means things which are used on board the ship. It can be mechanical equipments and instruments and eatables and everything which is used on board a ship is called as stores. And when you import stores into India to be supplied to foreign going vessels, then it is exempt from import duty. The stores, like equipments that we are importing into India to be supplied to ships, which ships? Foreign going ships. Then that importation of equipments and appliances and all is exempt from import duty. But in this case, as the supply was to oil rigs in India, which is India, not foreign going vessel, so therefore it was taxable. They said that import exemption will not be given. So therefore it said cannot be considered as export. Therefore, these imports are not eligible for exemption. These imports means the stores that you have imported into India for supply to oil rigs. Those imports are not exempt, and this will not even be called as export. So export benefits which are available will also not be allowed to you. Lot of things together. Then another case is there, Kiran spinning mills. It says this is for warehousing case. Taxable event occurs when the custom barrier is crossed and not on the date when the goods had landed in India or had entered the territorial waters. In case of goods which are deposited in warehouse, the custom barriers would be crossed when they are sought to be taken out from the warehouse and brought to the mass of goods in the country. Understood? When we file that second bill of entry for taking out the goods from the warehouse. Then in case of warehouse goods, another case, APAR. This was the original case of Bombay High Court. Later on, this is the Supreme Court ruling. In case of warehouse goods, the goods continue to be in the custom bond. Hence, import takes place when the goods are cleared from the warehouse. They have to be removed from the warehouse. Then only the import will take place. Then there is an export case, completion of export. When does the export complete? So it says export is complete once goods leave Indian waters and the property passes to the purchaser. So in case of export, what happens is that this is the land and this is the 12 nautical miles. Okay. So if any ship leaves here, export begins. Export begins when the goods are put on the ship, and export ends when it crosses the territorial waters. So this is when the export ends. So suppose if the goods, there was an interesting case. If the goods drown within these 12 nautical miles, suppose goods are taken on board the ship, but it drowns, it doesn't leave the 12 nautical miles, then can we say that the export is complete? No. Export is not complete. So therefore the assessee was denied the export benefits because the goods have drowned within 12 nautical miles. So export is not complete. If the export is not complete, export benefits will not be given. Then see Asian Foods, relevant date for exports. Date of actual permission of the proper officer granting clearance and loading of goods for export is relevant, and hence any notification issued after that date will not affect such exports. Now this is based on section 16 that we will see later on. What is the rate of duty? Section 16 says that rate of duty for exports is to be taken when this permission is granted. Clearance permission. So clearance order, you can say. Clearance permission means clearance order. When the clearance order is given, that is the date when you have to see the rate of duty. If there is no rate, then it cannot be applied later on. Then another interesting point is given there. Next para. No export duty leviable on goods cleared from DTA to CES. Now this is an interesting point. If you clear goods from domestic tariff area to CES, now in GST also we had studied this point. These are called as zero rated supplies. These are called as zero rated supplies in GST. Do you remember? Very good. But let me explain this point. Now this is India, the landmass of India. In India, we have got the special economic zones in which there are various units, and the rest of the area is called as the domestic tariff area. The rest of it is called as the DTA, domestic tariff area. Now, if a supplier is supplying goods from DTA to CES, then we consider it to be as good as export. It is considered as deemed export. In GST, this is considered as zero rated. Just like export, zero rated includes two things: actual export and supply to SEZ, right? So in GST we call it as zero rated. From customs point of view, we call it as deemed export. So this is deemed to be export. The purpose of this deemed export is that the duty which are chargeable here, like for example in earlier times there was excise duty was exempted. If the goods were supplied from DTA to CEZ, it was called as deemed export, means there was no excise duty. In present times there will be no GST because this is zero rated. So for that purpose this is called as deemed export, for purpose of exemption of GST, exemption of excise duty, etc. Not to impose export duty. Now see, when we call it as deemed export, like it happens. Let's take another example. Now there is a person in my office. Her name is Divya. Now she considers me to be like her father. She tells me that you are my office dad. So I'm like her father. Now like father means what? That I support her in everything. I support her in education and this and that and whatever advice she needs. So I'm like a father in terms of those things. Now I accept that okay, you are my daughter. Does that mean that tomorrow she'll file a claim on me and say that give me my tuition fees and maintenance cost and this and that, like you can ask from your father? No. Then I'll say no, who are you? You are not my daughter. So till the time it is about advice, yes, I am deemed to be your father. But if you ask money from me, you start asking pocket money and education money and other stuff, sorry boss, I'm not your father. So you cannot apply the logic both ways. Similarly it happens here. See, on one hand we say that exports, if there are exports from India to outside India, then a lot of exemptions will be there. So on one hand there are exemptions and benefits which you get, like GST exemption, excise exemption and such benefits. On the other hand, there are export duties also, like we had seen on those skins and leather, snake skins. There is export duty also. So on one hand when we export we get benefits, and on the other hand you are liable to pay export duty also. Correct? So you are entitled to both. You are entitled to benefit and you are liable for duties. Now will this also come under double concept, double entry system, that you are considered as deemed export? DTA to SEZ is deemed export, means you can take these benefits, the benefits will apply, and the export duty will also become payable. No, that cannot be said. So export duties will not become payable in case of supply by DTA to CEZ. Okay, export duty will not become payable. So the reason given by the court is that the deemed export concept is for benefits, not for charging export duty, not for this purpose, but only for the benefit purpose. So that is explained here. See, Union of India versus SR Steel Limited. This is the case. 2010 255 ELT. ELT means Excise Law Times. This is a publication name, like you have got Taxman and CTR for DT cases. So this is ELT. Supreme Court judgment. In case goods cleared from DTA to CEZ, the said goods are deemed to be exported but only for the limited purpose of allowing export incentives to the seller. Same cannot be deemed to be exported for the purpose of levy of export duty. Section 218 of the Customs Act defines export means taking out of India to a place outside India. Says located in India is not a place outside India. Hence goods cleared from DTA to CEZ cannot be regarded as exported for the purpose of levy. Okay, and the CEZ Act of 2005 doesn't provide for levy of customs duty. Therefore, the definition of export under CEZ Act, which provides that goods services provided from DTA to CEZ will be regarded as exported, cannot be taken for the purpose of levy of export duty under the Customs Act 1962. Hence, no export duty will be chargeable. Okay, great. Sometimes somebody may ask a question. Then going on to other definitions, simple definitions are there then. Goods. What is the meaning of goods? Goods means, goods includes, it is an inclusive definition, vessels, aircraft, vehicles. So the vehicles or the aircrafts or vessels which bring the good into India are also considered as goods. So that means that duty can be charged on them also. But in which case, if they are permanently coming to India. If a vessel is being imported into India, if I import a boat, then I'll have to pay duty on boat. I'll have to pay duty on ship. I have to pay duty on aircrafts. Like Indigo purchases Airbus aircrafts and brings it into India. They will be liable to pay import duty because now they are becoming part of the Indian goods, right? Then vehicles, trucks being imported into India, motor vehicles being imported into India, they are liable to import duty. Then stores. Stores means the things which are used on the ships. We can import them and then supply. Baggage. Baggage means the passenger who comes in brings the baggage with him. That baggage. Currency. Negotiable instruments. And any other kind of movable property. So import can be only of movable things. Obviously. How can you import land? Not possible. And the duty is payable on goods belonging to government also. Okay. Then imported goods. Any goods brought into India from a place outside India and does not include goods which have been cleared for home consumption. After the clearance on payment of duty, they will not be called as imported goods anymore. They will be called as normal goods. So imported goods means goods which are yet to be duty paid, means on which duty is yet to be paid. They are called as imported goods. Similarly, export goods, any goods which are to be taken out of India to a place outside India and goods brought near customs area for export purposes, means the goods which you enter the customs area for export. Then dutiable goods, any goods which are chargeable to duty and on which duty has not been paid. Dutiable means when the duty is not yet paid, they will be called as dutiable. And goods continue to be dutiable till they are not cleared from the port. Once goods are assessed at nil rate, they are no more dutiable goods. Now, in many cases there are nil rates or exemptions. They will not be called as dutiable. Dutiable means those on which duty is payable. Duty payable but not paid. Once paid, then they will not be called as dutiable. They will be called as duty paid goods. After payment, they will be called as duty paid goods. Till the time the duty is paid, they will be called as dutiable. Then this definition is very important. Mark it as very important. Asked many times in the exam. Foreign going vessel or aircraft. Now, as I told you just a few moments ago, that when you import stores means which are to be supplied to ships. Import stores, like you are importing equipments, materials which are to be used on ships. Import duty becomes exempt if these stores are imported for being supplied to foreign going vessels or aircrafts. So we are going to supply tomorrow or day after tomorrow to foreign going vessels and aircraft, then import duty becomes exempt. So in that context, this definition is used. What is a foreign going vessel or aircraft? We are going to supply ship stores to them and claim exemption. But what is a foreign going vessel? So that definition is given here. That vessel or aircraft engaged in carriage of goods or passengers between any port or airport in India and outside India. Simple. A vessel means ships, aircraft means aircrafts, which come into India, go out of India, come into India, go out of India. They are called as foreign going vessels or aircrafts. Simple. So a ship is coming from Dubai, will unload some goods, take some goods and again go to Dubai. So that will be called as foreign going vessels or aircrafts, which are regularly employed in this import-export. Whether touching any intermediate port or airport in India or not. So sometimes a ship may come to Bombay, Dubai to Bombay. From Bombay it is going to Cochin, and from Cochin it will again leave for Dubai. So it is touching two ports in India. So first it comes to Bombay, then from Bombay it is going to Cochin. From Cochin it is going to go back to Dubai. So from Bombay, when it is leaving, from Bombay, when it is leaving, what will it be called as? Domestic ship or foreign going ship? It will still be called as foreign going ship. You have to see the ultimate destination, not intermediate destination. So it says whether touching, even if it is touching an intermediate port in India, it will still be called as foreign going vessel. We have to see its ultimate destination, not the immediate next stop. Okay. Similarly, in case of aircrafts, it happens. Foreign aircrafts come to India, like a Singapore Airlines flight is coming to Chennai from Singapore. So it will touch Chennai, then it will go to Bombay. Then from Bombay, it will fly back to Singapore. It happens. And includes. And then it says it includes. So all aircraft, first the definition is the defining definition, that all vessels and aircrafts which are engaged in carriage of goods or passengers, it can be a goods or passenger ship or aircraft, between any port or airport in India and a port or airport outside India. So these will be called as foreign going vessels or aircrafts, even if they touch any intermediate port or airport in India in between. And includes naval vessels of foreign governments taking part in naval exercises. Foreign navy vessels come to India, they enter the 12 nautical miles to do exercises, and then they will leave. So they are also foreign going vessels. Then any vessel engaged in fishing or other operations outside the territorial waters of India. So if we are using a fishing vessel, we are going to 100 miles, 75 miles outside the landmass and do fishing and then come back. So when we are going out, we will be called as foreign going vessel if the fishing or the other activity is done outside the territorial waters of India. Okay, outside 12 nautical miles. And thirdly, any vessel or aircraft proceeding to a place outside India for any purpose whatsoever. For any purpose whatsoever. Any vessel or aircraft which is going out of India, its destination is outside India. Now this can be even a plane which is going for repairs. A plane requires some overhauling or repairs, and therefore it is going without any passengers. It is going, only the pilot is there. It is taking the plane to UK for some repairs, and then it will come back. So when it is leaving India, it will be called as foreign going vessel or aircraft. Or it can be a hired plane, like Farooq Haque has hired a plane for his class. So all the students, we are going to go to Maldives or Mauritius. So we'll hire the whole plane. So it's a domestic plane of Indigo, but right now we are taking it to Maldives or Mauritius for 7 days, fully paid tour from Farooq sir. For all the meritorious students. So we'll go, we'll hire the whole plane, chartered plane. So when we charter this plane, normally that plane was flying in domestic market, but now it is chartered and it is going to go to Maldives. It will be called as foreign going vessel or aircraft. The next is the definition of coastal goods. Coastal goods means goods other than imported goods transported in a vessel from one port in India to another port in India. Like goods are moving from Visakhapatnam to Kolkata through a ship. So those will be called as coastal goods. These are Indian goods, neither imported goods nor export goods. They are Indian goods. They'll go from one place in India to another place in India. They are called as coastal goods. The next is definition of customs area. What do you mean by customs area? Customs area means the area of customs station. Customs station means the whole port. Customs stations means port, airport, etc. And within that complete port, airport, there will be a designated area called as customs area, in which the imported goods or export goods will be kept before clearance. Non-duty paid goods will be kept there before clearance. So that is called as customs area. And we'll see how these are appointed, who appoints them. The next is entry. Entry refers to document that you have to file for entering the goods into India. So in case of cargo import, bill of entry is there. This is the document that you have to file for entry purpose. In case of export as cargo, shipping bill or bill of export is there. Shipping bill you have to file when the goods are being exported through ship or aircraft. If it is going to go by ship or aircraft, then shipping bill. If it is going by road, that is through truck, through land custom stations, then it is called as bill of export. Okay, these minor things you have to remember. And goods imported or exported as baggage, you have to file a declaration. There is a special declaration in section 84 that we'll see when the time comes. Then person in charge, this is also important. Mark it as important. Person in charge, this is also asked in the exam. Person in charge. So in case of vessel, means ship which is coming into India, master of the vessel. Now to remember these, just imagine that there is a ship coming into India, big ship. So the master means the control, the person who has the ultimate control of the ship, he will be called as the person in charge. So write down Jack Sparrow. To remember, Jack Sparrow, Pirates of the Caribbean, have you seen? So he is the master of the ship. Yes. Then in relation to aircraft, the commander or pilot in charge of the aircraft, whoever is the main chief pilot or the commander, he is the person. Then in case of railway train, the conductor or the guard or other person having the direction of the train. Very funny definition. Conductor sits on the last dabba, okay, last bogie, and he is called as the person having direction of the train. Who has the direction? The engine driver. But the driver is not considered as person in charge. I don't know why. Driver is not considered as person in charge in case of railway. It is the conductor or the guard. Okay. And any other conveyance like truck or bus or something like that, it is the driver or other person in charge of the conveyance. Normally the driver, but if there is some other person in charge sitting there, then that person. Simple to remember. Then stores means goods for use in a vessel or aircraft and includes fuel, spare parts and other articles of equipment, whether or not for immediate fitting. Like spare parts are carried on ship. If needed anytime, then they can be fitted. Then there is a definition of custom broker, that no person shall carry on the business of custom broker. This is a very simple, you can even exclude it or just go to it once. There are custom brokers. Custom brokers, the work of custom brokers is to help the people in clearance of import export cargo, documentation and all. So that is custom broker, and they do very good business in practical life. So if you want to become custom broker, you can become. What you have to do is pass an exam conducted by CBEC or CBIC nowadays. So you pass an exam conducted by the Customs Department of CBIC, and then you can become a custom broker, certified customs broker. So it says, see, no person shall carry on business as a custom broker relating to entry or departure of a conveyance or the import or export of goods at any custom station unless such person holds a license granted in this behalf in accordance with the regulations. So you have to obtain this license, and then you can help people in import export for a commission. They charge commission. And the board may make regulation for the purpose of carrying out the provisions of this section. In particular, such regulation may provide for the authority by which a license may be granted under this section and the period of validity of the license, the form of the license and the fees payable therefore, the qualifications of persons who may apply for the license and the qualification of persons to be employed by the licensee to assist him in the work of custom broker. Your employees will also have to have qualifications. Then the manner of conducting the examination, this is that exam which is conducted by CBIC, and if you pass that exam, then you can become a license holder. Then the restrictions and conditions subject to which the license may be granted, including furnishing of security, etc. The circumstances in which the license may be suspended or revoked, and the appeals, if any, against the order of suspension, revocation of license, and the period within which the appeal may be filed. So all these things will be made by the CBIC. Regulations will be made. So that was a small chapter, and a few points were important in this, which you have to remember. A few definitions which are important, and the concept of import. When does the import takes place? The taxable event. Very simple point.